It is 9:40, and today is July 18th. This is the Public Safety Committee in room 1010. I'm Councilmember Mitchell Englander, Chairman of the committee, and I will be presiding over this. It looks like all by my lonesome, unless other council members come. I believe that Tony Cardenas is on his way. Jan Perry is excused. So is Councilmember Ed Reyes and Councilmember Dennis Pizine today for official business. We've got 2 public comment speaking cards. We're going to open it up with public comment first. Phyllis Doherty. Come on up.
Good morning. Should I say Chairman, Councilman? It's an honor to speak with you and be here today. I wish it were on a better topic, but I'm here today sort of to join with you in the mourning the death of a city department, because LA Animal Services is probably not going to recover from what is happening to it now. I've always been the staunchest optimist, as you know. I've been coming in and saying things will get better. I've been telling the employees that. Can't tell them that now. We've lost the outside terrorism. I don't know if you saw the notice that the ADLLA will no longer be threatening people. They haven't been for a long time, other than just on paper. But the terrorism now has gone internally. It's from the staff, from the general manager, from the director of field operations down in management, and the employees are literally paralyzed. They're losing hope and they're losing loyalty, and I can't disagree with them now, and that's the hard part, because I've been their staunchest supporter and fighting with them. But I want to remind you that the Department of Animal Services is not a charter department, and if you don't have a copy of this, I'll give it to you. You have full control over this department, and it should not be under the commission, which also degrades the employees every time they have an opportunity. They are part of the terrorism against the department, against the employees, not part of the health. The other thing I want to be sure that you know about is that there's been an internal audit of the Anti-Cruelty Task Force, which I have been saying for years has not been doing its job. It's pathetic that 20% of the cases that were handled by the detectives were done properly, and that's only something like 8 cases. We have not had one major dogfight bust since they've been there, and at one time we had 20 full-time employees assigned.
Okay, thank you. Did you want to submit that as part of the record?
I can.
Only if you like.
Yeah, I'll give it to you.
Okay, and then we had another speaker's card here for public comment. Is it Dr. C.T. Williams? Yes.
Dr. Clyde and/or Dr. Tom Williams from El Sereno, LA 32 Neighborhood Council board member and recipient of one bill from the LA Fire Department for one of my 2 lots, adjacent lots, for brush clearance. I'm going to refuse to pay it because one lot is driveway, one lot is buildings. But they did not give me a double bill because they're 2 separate lots. Inconsistency of enforcement of regulations. I know the regulations forward, back, and I know a lot of places which are not being cleared. Adjacent lots to mine, Mount Washington, Benedict Canyon, and Mandible Canyon. All of these areas where right now redeployment of our scarce fire department resources has been done in order to be there when the brush burns. Why does the brush burn? Because lack of enforcement of the regulations that are on the books, the most stringent in the United States and thereby the world. So we're a world leader in regulations, but not in the enforcement. And here's one, a $23 fee for an inspector who charges $160 fully loaded. There seems to be a few minutes given to the paperwork and that's it. In reality, all you have to do is go on Google Earth and look at Benedict Canyon, Mandible Canyon, Mulholland Drive, all of these areas where brush clearance is not being enforced. So consistency in the year 2011 brush clearance citations, and I'm going to refuse one of them. Thank you.
All right, that's it for public comment speaker cards. We've got 2 items on consent except for one. Item 1 has 1 speaker card, so we'll go ahead and move 2 with communication from the chair.
Very good.
And then item 1, Phyllis Doherty. Yes, please.
This is Phyllis Doherty of Animal Issues Movement. This is a donation by Bayer for flea and tick product for the animals in the shelter. And I want you to know that this is a renewal of a contribution that was obtained by, at that time, Acting General Manager Kathy Davis. You may recall that for 1 year she was the Acting General Manager, and she and Linda Barth ran the department. And that was the year that we really made progress. We got the administrative citations in. They redid work on the municipal code. And Kathy spent her time also meeting with outside companies to get donations. That year, we received $150,000 in cash, 3 times what has ever been received by the department, plus this product. This product that you're accepting today is a renewal of that donation because of her personal relationship with them. And it probably will not happen again because Kathy Davis was placed on administrative leave on Friday by the current general manager.
Okay, thank you. Go ahead and move item 1. It's consent from the chair as well. And then on to item 3. If we can get some instruction from the city attorney on item 3 before we open that up as well.
Certainly, Councilmember Chair. This is the time and place for your appeal of the hearing determination assessing fees for brush clearance. Each speaker will have a maximum of 2 minutes to present any newly discovered or additional evidence that you would like the Public Safety Committee to consider in its determination of whether or not to approve the assessment of fees previously determined by hearing before a hearing examiner that was appointed by the Fire Commission. You will not be allowed to ask questions or to engage in debate with the fire department or the committee. You have 2 minutes to present your evidence when called by the speaker, by the chair.
Thank you, Ms. Jackson. And the first speaker card is Dr. Clyde Williams, once again.
And just to clarify the record, I am Janet Jackson, Deputy City Attorney's Office.
This is for only evidence, no public comment
this is for
regarding the general.
new evidence. New evidence pertaining to your particular claim.
If your comment, if you are here for a hearing appeal, what I just said applies to you. If you are making a general public comment, it does not apply to you.
Okay, then I retire.
Okay. Then the next speaker card is Ms. Sarah Tall.
Good morning.
Excuse me, before you begin. The report and proposed decision on assessment for Sarah Tall is on page 131, and it involves mailing address 16359 Armstead Street, Granada Hills, California. Zip code is 913443012, and it's Council District 12, and it's package number 2010181026. The hearing date was May 25th, 2011.
Yes, I sent it in the evidence, page number 1 through 5 previously. Page number 6 and 10 are the new pictures that I'm presenting today. I own the two properties, subject property and adjacent to the property is 11711 Andrew Avenue. And I received the city notice that I need to clear the brush May of 2010, which I did. And then October 20th of 2010, they sent the red tag that I need to clear. So I hired the licensed contractor. There's a two dead tree problem, one in the front and one in the back. And the city hired the contractor, they cut down the trees. In 2 days later, city hired the contractor, came to the property, and they're cutting down the trees. They're cutting down the trees, pictures on 6, the new pictures on 6 and 10, those trees belong to other property, 11711 Andrew Avenue. And as you can see on the picture, those are the healthy trees they're cutting down. And then I've been living there 15 years, those trees are valued to my property, but they're cutting down the healthy trees in the wrong property. So all I'm asking you to do is, my negligence in not cutting down those two trees is my fault. But also wrongdoing, the city hired the contractor cutting down other property trees, they're big mistake. But I just want to put everything behind, so just let it go. Please help me not paying the, those charges on that property. Thank you.
Right. And I am now joined by Councilman Tony Cardenas. Good morning. On this, I don't have the new photos that you said you claimed you submitted.
Page 6
Do I have
through,
them here? Okay.
yeah,
Here.
page 6 through 10, I draw a line there, property line over two properties. Page 8, that orange line is property line over two properties, 11711 Andrew Avenue. I own it with my ex-husband. And then the other one, 16359 Armstead Street, I own it by myself. And then you can see the pictures on number 8. They cut down the healthy trees from my other property. And so is number 9, and so is number 10. They're doing it wrong property, cutting my healthy trees.
Do we have any comments from the fire department on that?
Good morning. My name is Robert Knight. I'm the captain in charge of the brush clearance program for the fire department located in Van Nuys. Every year, the fire department clearings inspects over 132,000 properties located in the very high fire hazard severity zone. This subject property here is located in the zone. It was inspected. It was found to be in violation. The appeal is that she cut down her two dead trees, but also the fire code does require property owners to maintain all healthy trees and everything else on their property according to the code and fire department requirements. There were other violations that were found on the property that were also cited for. The property owner failed to comply by her due date. Therefore, the fire department took action and moved forward in abating the hazard. Her now appeal, based upon her hearing that she had on the 25th, she is now saying that we were on the wrong property. That information I'll have to look back and confirm, and I'll report back to the committee.
Okay. As a recommendation from the chair, then I'd suggest that can we pull this one item out and hold this one until the next meeting? And you can report back unless you have anything on that.
Yeah, it appears that the petitioner isn't saying that the fire department did not do some mitigation. It appears that she's saying that some or all of the mitigation that took place was not on her property. So I know that you inspect over 130,000 properties or whatever the figure is that you just told us. It's good that we get it right 99.9% of the time. But if you're the property owner of that 0.001%, then that's all that property owner cares about. And with all due respect, that's the only responsibility that property owner has. We have responsibility of that 130,000 inspections. So if we could make sure, as the chair said, to have the department clarify for us as to whether or not the department is correct and did in fact mitigate this particular property, and therefore this charge is correct, or if the fire department can actually verify whether or not mitigation was taken care of, and it's not the responsibility of this particular property owner. I think it's only fair and appropriate that we give that opportunity.
Great. And then so, Ms. Stahl, so what we'll do is we'll bring it back. The fire department will verify the new information that you provided. I appreciate you taking the time to come down here this morning to provide the new photos as well, so they can verify that. As Mr. Cardenas just had stated, mistakes happen sometimes. So we're not suggesting that that's in fact what happened this time, but they're going to take the new information. They'll review that as well and come back to this committee and report back that information from their findings.
Ms. Tall, if you could wait until after the meeting, the fire department and I will speak with you and explain the procedure to you and what will happen next.
Okay? Thank you very much.
Thank you.
Okay, the next item is Isaac Weintraub. Is that correct? Yes. Yes.
And that is found on page 59. And this is Council District 5, package number 2010174034 for mailing. The property address is 03824 Sheerview Drive.
I'm sorry, what page was it?
Page on
Page
the report?
59.
59. Thank you.
Hearing date May 26.
Yeah, the reason I'm here is because...
Just one moment.
Okay. Oh, he told me to stop.
Okay.
Yeah, there is... excuse me. The reason I'm here is because the letter that we sent to explain what happened, I don't think the main subject was not addressed. We did not talk about a violent neighbor or anything of this nature. This property is rented. It was rented to somebody that basically the whole year was in the process of being evicted, and it took, and that's what the paper I gave you, it took a year to get him evicted. He was apparently, as I found out after this, he was also dealing with drugs. He had 2 big dogs. He did not let me in for anything, so I could not go in and bring my own gardener to clean the brush. That's my issue. And the other issue is that, I already paid on it about $400, and now the cost of clearance is $500, administrative fee is $1,000, which looks to me a little exuberant in the famous words of whoever. And basically, I don't care to sign approval for the fire department to clean it every year for $1,000 and forget about it. It's fine with me. The other thing between, so to say, out of it, I have to finish, I did not get any bill of whoever did the work, okay? Here I'm charged for about $2,000, and maybe the work itself, that I don't know who did it, was not paid whatever amount. So that's the issue.
Okay, thank you. And if we could have some information from the fire department on that?
Sure. The subject property here on Sheerview Drive, the appellant was denied its hearing due to the fact that they did not clear the property by its scheduled due date, and is claiming that because they were going through an eviction, well, the tenant who's occupying the property, he was unable to access his property and complete the brush clearance himself. The hearing officer denied that claim. The appellant is not giving any new or additional evidence here at this committee, and therefore the fire department took action and moved forward and cleared the property itself. The hearing officer weighed that the property owner is still liable and still responsible for that property regardless of the dispute with his tenant that's occupying the property.
Okay, thank you. Well, as presented by the fire department and your argument as well, and I think you've got a great argument that you had a tenant that wouldn't let you onto the property. Unfortunately, it's not under the purview of the city of Los Angeles. It's a private matter and dispute between you and the tenant, and it sounded like you were having a problem with them already and going through an eviction process, which took some time as well. And maybe, and I don't know the answer to this, and this is really a civil matter and a private matter between you and the tenant. but it sounds like you might have cause of action to go after them for this cost as well. I don't know. That would be between the two of you and part of your lease agreement with them.
No, they are out, that's not the issue.
But, sir, I just wanted to address your questions and concerns and let you know that it's unfortunate, but it sounds like it wasn't an issue that you were in compliance or had somebody else clean up the property, or for that matter, in the last case, it might have been the wrong property. This is the correct property, and that's not in dispute. So I think it behooves this committee to uphold the assessment per the fire department and move this on as well. So.
I have a question for Mr. Weintraub. Were you successful in having this tenant evicted?
Yeah, he's now evicted. This is the paper that I put.
But when did the tenant vacate?
I believe January of this year.
Oh, January of this year. So it appears that your attempts to access the property because of the big dogs or what have you precluded you from addressing issues on the actual property, but it's interesting that the fire department hired somebody to do the clearance, and it appears that the clearance was completed while the tenant was still on the property, because October 19, 2010, according to our records, show that somebody was able to access the property. I don't know if they're friendlier to dogs or what, but it didn't keep them from cleaning the property.
Can I answer? I'm not supposed to answer. I don't know. I'm not supposed to answer.
I can ask you a question. What happened?
See, the guy was apparently, he was afraid of authority, okay? When the sheriff came to evict him, he was not there. So maybe when the guy came to clean and he saw somebody from the fire department, he let them in. He was afraid of any authority, but was not afraid of me.
The question of the fire department, when we send cleanup crews to go follow through and mitigate brush clearance and things of that nature, do we send people with badges, or does the crew go, and therefore if they can't gain access, do they then after the fact report to the department, or how does that work?
Normally the procedure is that when the contractor is awarded the bid, the contractor is giving a document that says official fire department notification that the fire department has ordered an abatement of the hazard on the subject property. If the contractor is confronted with a property owner who fails or refuses to put him on the property, we're contacted, and then the fire department responds out there to mitigate the situation.
Is there anything on this file that shows that the contractor was unable to gain access?
No.
So there's nothing on file showing that they had to go back and forth with the department in order to gain access?
No.
Okay.
No, sir.
Thank you.
Okay. And the final card on this item is Alan Patel.
Good morning.
Morning.
Which page?
I don't know, so let us know.
Is this for Sun West Mortgage?
No.
Patel has several properties. One is beginning on page 23. Actually beginning on the first page.
$149 to clear, $1,100 for admin.
Actually on page 1. That's the first one is on page 1. Patel has...
And page 23? Or just...
Yes,
How many properties total are there?
5, 6, 7, 8. I show 8 properties, 8 different parcels.
Are you here to speak on all 8
Yes.
parcels? Okay.
Okay. Are they adjacent?
Yes, sir.
Okay.
Hi.
Looks like, yeah.
Good morning. There are 14 lots all adjacent. Just 8 of them had the violation. Anyways, when I went to the appeal, the guy that was listening to me, he misunderstood what I said. Here it says I got denied the appeal because I owned the properties before. I was the lender, and I have evidence that I was the lender. In 2006, I lent money to a developer to develop the properties. So I foreclosed on September 29, 2010, and the violations were sent on July 14, 2010, in August, prior than me foreclosing on the property and ever owning the property. And the violations were also sent to a different person, not to the owner of the property. It was sent to some lady that frauded the developer that I lent the money to. She frauded him, promised him financing to develop the property, and she got her name on the title, and the fire marshal sent it to the wrong person. So the notices were sent to some fraudster. I was the lender. I never owned the property. I never got any notice. I agree with the brush clearance. I just don't agree with the $8,000 administration fees, because I never got any notice. I would take care of it immediately if that would happen. And I did explain it to the person when we had the hearing. He just thought I owned it in 2006 when I was the lender, and I repurchased it. It says right here, you're denied because you owned it, and then you repurchased it. I never repurchased the property. I was just a lender, and I foreclosed on the property, on the 14 lots, because they never paid my mortgage.
I got it. Okay. So, and it's unfortunate that there's been a lot of that in this economy as well. And having said that, you were the lender, but then when you foreclosed, you were actually the owner of record at the time that these were issued, and you're not denying the cost of the clearance. Is what I heard, and I'm asking you that question for clarification. You are accepting and admitting the fact that you owned it during that period of time. No.
If you see, I owned it on September.
And if you can speak rather than shake your head yes or no,
Yeah.
so just so we have it in the record.
I wasn't allowed.
Can't pick it up on microphone.
I became the owner when I foreclosed on September 29th, 2010. Okay? The notices were sent in between May and August 2010. That's when the work was done. I owned it afterwards. And again, I was the lender prior. I wasn't the owner. Just like B of A is a lender, I was a private lender to a developer on those vacant lots. I owned it after the notices and after the work was done. And furthermore, the notices were sent to not to the previous owner, it was sent to some other lady.
Okay. And what information do we have from the fire department on this?
The fire department utilized the information that was available on the county assessor's information. That is the address that we had that was on record, the legal address for us to mail it to, and that's what we did. The property was inspected and found in violation on July the 14th, 2010, and we sent it to that address. The mail was sent out. It was not returned as undeliverable. Therefore, we went ahead and took action and moved forward with it. The fire department followed all of its procedure. If the gentleman here purchased the property, those liens would be attached to that property.
And I will note for the record on page 2, the proposed decisions and recommendations, the hearing officer did appear to understand the property situation and did opine on the matter. Quote, the appellant provided documentation to prove that he had purchased the property on September 29, 2010 at a public auction. While some encumbrances might be extinguished, weed abatement levies and fees are not removable without payment via a tax sale. Therefore, it appears that the cost of clearance and the administrative fees were properly assessed, and the total assessment should be upheld.
Okay. Well, based on that, and again, going back to understanding, this real estate market and all the foreclosures, and the fact that the city attorney has explained, and it was explained in the appellant process as well, is that weed abatement and assessment fees for that are part of the property when you acquire the property. Even if it took place prior to your recording of the property or ownership, they're carried forth. As with property taxes and other items, those are not wiped out. And so it's unfortunate, but it sounds as if you've inherited that with the property as well. And so it'll be the recommendation of this committee and the chair to move this forward as proposed by the department. Do you have anything further?
I have a question. These are adjacent parcels, correct?
Yes.
Yeah. And the fire department is assessing $1,112 times 8 times across 8 adjacent parcels.
That's correct.
I'm looking at some of the other administrative fees. Some are above 1,000, some are less than 1,000. What is it in this particular case that the fees were above $1,000 or a little bit on the higher end?
That was based upon the accounting services section that they did an analysis to see what the cost of the administrative fee is, and it changed throughout the 2010 season. So it adjusted. So there will be some in this report that will reflect slightly above 1,000 and slightly below.
Mm-hmm.
On the assessment, and I'm aware of the cost clearance part of it, but on the administrative fee, is that to be cost neutral as well? Is there any
It's full cost
profit
neutral.
in there to the department or to the city of Los Angeles, or is it completely cost neutral for time?
It's cost neutral, yes.
Okay. Anything further?
What's unfortunate that you have so many fees, like you said, $149 clearance per parcel isn't that much to chew, but unfortunately you have 8 separate parcels, and each parcel requires its separate documentation, regardless if they're adjacent or not. But the fact of the matter is you did acquire this. It appears that at auction, this property went for sale, whether you were the prior lender on it or a third party who purchased it at the auction. The bottom line is these are the kinds of assessments that actually go with it. And bad timing too. It looks like the process crossed from the beginning of the process on July 14th, and your purchase in the latter part of September was right in the middle between the notifications and the actual clearance. So I'm trying to figure out a logical.
May I say one more thing?
Sure. What's that?
Well, these lots are packaged together. Right now, they're on the market together. They were only sold as a package. They're just have different parcel. But
Sure.
no one would buy just one parcel. You need to buy both of them to access all of them together.
Mhm.
So I think what would be fair is just one administration fee. Just it's all together. Right now, it's on the MLS, sold as a package.
Sure.
I
But-
lent it on the package. The previous guy bought it as a package.
Yeah, but the difference is that the department didn't have to do, they had to run each one of these separately and process them
Exactly. We
separately.
don't have that flexibility. Basically, what you're doing is you're explaining to us a fact of the matter that, in the practical sense, when it comes to real estate sales, that these parcels will probably remain together for a long time, even though, but the fact that they're separate parcels, the department had to administer this legal action with each individual parcel. You're absolutely right. Logically speaking, being that they're located in the same place, you would think that they could just bundle them together and handle them as one property. But unfortunately, for legal reasons, we did not have that flexibility on our end. So we're now speaking after the fact of the actions that were taken by the city department, the fire department, and the fact of the matter is that's the way they had to handle it. So they had to do separate notices, they had to do separate filings, they had to keep separate files on each individual parcel. And that's just their requirement by law. Now, if they tried to lump them together, oddly enough, then you would have a case to say that they violated their requirements by making it easy on them and on you. And or a neighbor could actually sue and saying that's not fair. I have 2 parcels in different parts of town, and they didn't bundle them together because I'm one owner. Do you get what I'm saying? So I just want to explain to you that even though what you're saying is logical, I happen to have been a former real estate broker, so I think I know exactly what you're referring to. But at the same time, now we're dealing with legal requirements and responsibilities upon the city that they cannot, it's called without prejudice. Without prejudice, they have to treat each parcel as its own entity with its own notifications, its own process. And unfortunately, amassing over $1,000 per parcel in administrative fees. But I remind you, having been a real estate broker myself, that when you lend on properties, you're very well aware that your recourse is you end up with the property, with fleas and everything else included. That's the risk that is taken in this interesting game called real estate and lending and liens and mortgages, et cetera. So unfortunately, it appears that I'm trying to figure out a way, Mr. Chairman, a way to lump them together or what have you after the fact, but I have to be cognizant of the fact that if I do that for you, then I have to be ready to do that for anybody else that might have more than one parcel in this go-round of having assessments. And if we did that, then it would just have a domino effect of unfairness on other folk.
The only new information I have over here is that it was, the notices were sent to a different person other than the previous owner. Because I'm in good relationship with the previous owner that I lent money to. He's actually trying to buy it back to redevelop the property. And the whole time it was sent to some person in Northridge who was never the owner and never the person I lent money to.
But once again, that's the kind of thing that you might want to either go to small claims court with that third person or what have you. But the only thing, unless the city is gonna admit that they erroneously sent it to an address or a person that was other than on record at the county, as the fire department just mentioned, as long as they followed their responsibilities, they can't color it by sending it to somebody else. They have a standard procedure that they have to follow. And I don't know how that person got involved in being the address and person of record to be sent information, official information, but again, that was beyond the city's control.
She did a fraud deed, basically.
Yeah, and probably time will tell over time how that fraud occurred, and hopefully people can extract remedy from her on a different note. You get what I'm saying? But the thing is, we had nothing other to go by. If you're going to tell us that the city sent it to somebody on their own volition by their own mistake, then that's a different story. But if they're sending it on record to somebody that you've been able to verify was getting it, even though they interfered beyond the owner's back or the lien holder, et cetera, the bottom line is, if you're going to tell us that the city erroneously sent it to the wrong person, that's a different story. But if you're telling us that somehow this person infiltrated the process and actually caused him or her to be the one to receive this kind of information, and we followed that, then that's all we could do.
So with that, I'm going to wrap this one up. If you have that new information, if you want to submit it as part of the record, we could take that, but it'll be the recommendation of the committee based on the information and the facts that are presented to move this item forward as well. So thank you very much. Seeing no other...
I believe that there was a public comment card from...
we did public comment at the beginning of the meeting.
Okay.
Yes. And so I believe we closed out on those as well, yes.
I didn't get to hear?
We could play back the tape if you'd like.
No, okay. I'm sure I'll hear them in council.
Okay. And being no other items, then I'll move to adjourn the meeting.
Thank you. Lonely at the top.
Now I wonder what happened last.
Get here.